Sorry, we've just had a few technical adventures and okay, great. So first of all, thank you all for joining us. I know it's at the end of a long and packed day, so we really appreciate you taking the time for this. So my name is Megan Corrino. I'm managing editor of Just Security, which is an online law and policy journal housed at NYU Law School. I've had the privilege to work with each of the panelists here and here as authors on our platform, and in the case of Beck Hamilton, as one of our executive editors. I think recognizing that it is a long day, we won't do too much prefatory talk. Our plan is for each panelist to speak a little bit about their work, and then we'll do a Q&A at the end. And to sort of situate the work of each panelist, I will just briefly introduce them as we go down, sort of before each person speaks. I will just say kind of a couple of global notes about the presentation today. This has come out of thinking that people have been doing about issues at the intersection of international environmental law and public communication, community building, communication between governments and people. And each of the thinkers that we have today is an incredibly thoughtful speaker. Their work covers academia, diplomacy, litigation, organizing, and more. So I am so thrilled for each of you to get to hear from them today, and we're so pleased to be able to have the privilege of presenting them. So I will start with Camila Bustos. She is an assistant professor of law at Pace University and was previously a visiting assistant professor of human rights at Trinity College. She received a JD from Yale Law School, where she was highly awarded. And among other climate and justice work as a student, she co-founded Law Students for Climate Accountability, which is a national law student-led movement that is pushing the legal industry to phase out fossil fuel representation. Camila now serves as a board member for Law Students for Climate Accountability and for Save the Sound. Her research and scholarship today focuses on human rights and environmental law, and she's been widely published in leading legal academic journals. She is a frequent presenter on climate displacement, climate law, and environmental justice, and among other things, has provided expert testimony before the Canadian Senate and the Inter-American Court of Human Rights. So Camila, over to you.
Thanks so much for the space and for the invitation. It's so nice to be here, and thank you all for being here on a Friday afternoon. We'll try to keep it interesting and engaging. So my work centers on the intersection between climate change, human rights, and environment. And some of the thinking I've been doing related to the panel is this question of climate litigation and how to win, but then what happens after we win. So as some of you may be familiar, in the last sort of 10 years or so, we've seen this explosion of climate lawsuits around the world. And many of them are targeting governments, both national and subnational. Some of them are targeting businesses. And there's different theories of change, right, and stories that come forth in those cases. My work is specifically focused on human rights. So I'm really interested in how people are using human rights law and also remedies to think about their own stories and how to basically ensure that governments mostly, but also businesses, are protecting and meeting their obligations in the human rights context. So I'm mostly going to be focusing my remarks on an article that is forthcoming in the Vanderbilt Law Review, which is called Implementing Climate Remedies. And the reason I wrote this article was that before I even went to law school, I was part of a lawsuit trying to stop deforestation in the Amazon. I'm Colombian, so we worked with a group of plaintiffs and advocates to sue the national government. This was 2018, we won, which was incredible because we overcame a lot of the sort of legal obstacles like standing and causation. And then it's been 8 years since, and a lot of my thinking is what happens after you win, and how do we actually implement and ensure that a victory on paper doesn't stay on paper. So I basically have focused on what do we learn or what can we learn from existing literature on human rights. Climate may be a seemingly newer issue, but people and communities have been using law for a long time, particularly in the context of socioeconomic rights, education, health, And so what can we learn from that literature? And so what the article does is looking at 4 factors that basically I think are the factors that litigators should be thinking about when they bring this kind of lawsuits. And you can read it if you're interested and sort of all the academic details, but generally part of it is really talking about the commonality of these victories. And when we think about litigation and a successful implementation, there's 4 things. So I talk about supervisory authority, so courts basically retaining authority or jurisdiction over a case, meaning litigants can come back, right, and continue to either tell the story or try to hold the defendant accountable using different procedural tools at their disposal. Mechanisms to actually implement a decision, right? So in our case in Colombia, for example, the court gave really broad orders about nature's rights and the rights of future generations, but there really wasn't much else. And so you get in this interesting question of separation of powers and what courts can say depending on the jurisdiction you're in. But there is this sort of factor of mechanisms for implementation that is really important, which is we need a plan, right, after a victory to actually, especially if you're talking about like systemic remedies, national legislation, policy changes, that sort of thing. The cost of non-compliance, right? So who is actually going to put in the time to either get media attention or organize communities to push for that implementation and to raise the cost of non-compliance. So if a government feels that there's nothing's going to happen if they don't actually follow the law, then the likelihood of that implementation is very low. So precisely the question is, who are the networks of actors who are pushing for implementation? And there's other things I talk about, but generally that's the work. And so again, I'm really interested in how human rights are used to tell stories by litigants in climate litigation. And then also, after we win in court, how do we think about implementation and ensuring that we don't just get these grandiose statements from courts that don't change the reality on the ground.
Thank you. And I think the theme that you were talking about sort of transitioning from legal victory to actionable solutions is one that I think a number of the conversations today are going to touch on, and certainly something we'll discuss at the end. So thank you. And you should all check out her law review article forthcoming in the Vanderbilt Review. Next up, we have Naima Fafita, who is making extraordinary efforts to join us across time zones and geography. Thank you. She is the founder and director of the Moana Tasi Project, an environmental nonprofit that's working to advance dignified climate justice and migration pathways for Pacific peoples. With familial roots in Tuvalu and kin across the South Pacific, Naima documents the lived experiences and traditional ecological wisdom of communities navigating climate-induced displacement, while contributing to regional and international legal discussions on mobility, sovereignty, and self-determination in the context of climate. She also serves as a senior associate at Ocean Vision Legal, where she leads the development of the Ocean Guardianship Department, fostering partnerships with Indigenous and coastal communities. Naima serves as a member of the Commission of Small Island States on Climate Change and International Law Secretariat, counselor for the World Future Council, and a 2004-2005 Obama Foundation Asia Pacific leader. Her Pacific Islander and multicultural upbringing and world-embracing views have motivated her engagement in numerous environmental spaces, particularly environmental justice and nonprofit work, legal research, and policy transformation. And she is a graduate of the William S. Richardson School of Law at the University of Hawaii, where she studied environmental law with a focus on Pacific climate displacement and served as president of the Pacific Islander Legal Association. So with that impressive background, over to you.
Thank you so much, Megan. And hello, everyone. I'm calling from the South Island of New Zealand, where it's still quite cold, hence my turtleneck. Thank you to the organizers of ILW25 for inviting me to speak and to participate from afar. And it's wonderful to be joining the conversation alongside such a fantastic group. So Megan really summed it up there, but I can add a little bit of context. My work primarily bridges international environmental law, Indigenous rights, and climate justice in the Pacific region. And as Megan mentioned, through the Moana Tasi Project, which is a Pacifica or Pacific-led collective working with climate-affected communities to co-create response pathways that are grounded in local knowledge and governance. And there we focus on four main areas: climate justice, so ensuring that traditional knowledge informs legal and policy responses, climate responses. Environmental stewardship is the second one, which applies Indigenous ecological knowledge to governance, mitigation, and adaptation measures. The third one is advocacy and education, so building community capacity to defend land, resource, and cultural rights. And lastly, connection and culture, so preserving intergenerational knowledge and cultural practice as central to effective climate solutions, and holding space for cultural connection and community to gather and engage in their practices and have access to their Indigenous rights. So that's Moana Tassi. And then with Ocean Vision Legal and through the Ocean Guardianship Department, specifically, I work with ocean-dependent and Indigenous communities to strengthen legal and governance frameworks for marine ecosystems. And one of the primary aims there is to promote the recognition of ocean guardians through law. So I work with communities, governments, and institutions to develop and advance guardianship-based legal frameworks that reflect relational approaches to marine governance, and recognizing that existing ocean governance frameworks are rooted in colonial and exclusionary systems. So this work is intended to contribute, of course, to the long-term work of decolonizing ocean governance by supporting and amplifying the leadership and the knowledge and the legal agency of Indigenous and ocean-dependent communities, particularly those most affected by ecological harm and marginalization. So across both roles, I'd say my work is very much driven by a core question. What does dignity look like in the climate or environmental law space? And how do we use the law then to increasingly ensure that dignity for climate-affected populations, and especially those experiencing cross-border climate-induced movement or migration, which may lead to ex situ nationhood, are respected and acknowledged. So thank you very much, and I'm looking forward to the discussion today.
Great, thank you. And I think one thing that's interesting, kind of a theme that it sounds like is prevalent in your work, is this idea of sort of narrative building being a multi-directional project where the advocates are working with communities to understand what the communities want to express, and iteratively going back and forth between sort of that and the different dimensions of advocacy. So turning now to another dimension of work, Sue Benitez is coming to us from the world of diplomacy. She was most recently the U.S. Principal Deputy Special Envoy for Climate. For more than 25 years, she served as the lead climate lawyer for the U.S. State Department and played a central role in all major climate agreements, including the Paris Agreement. For many years, Sue led the legal office that was handling international environmental issues, law of the sea, science, and outer space. And while a deputy legal advisor, Sue also supervised the treaty office and issues related to East Asia, the Western Hemisphere, human rights, and international law enforcement. For the last several years, she's been teaching international environmental law and the climate negotiations at various universities, including the Yale Jackson School of Global Affairs, where she is a senior fellow and lecturer. And it's not written here, but also Chicago, I know, where she just recently flew in from. So Sue, over to you.
Thanks a lot. Can you hear me okay? Yeah, so as Megan says, my background is quite different from everybody else's. It's mainly as a State Department lawyer and also negotiator of lots of international environmental agreements. I'm going to focus on the climate negotiations, and I was really happy you gave us this topic because I hadn't really thought about what I did in terms of narrative, but it forced me to think about it, and I sort of came up with maybe 5 different ways in which narrative plays a role or has played a role in the climate negotiations. So the first one is that a kind of a pithy narrative can be used by a country or a group of countries to drive home a negotiating position, right? So negotiating positions are usually quite complicated. You put in a submission, it's 5 pages long. It's full of all kinds of different things. And it might get lost on the other countries. So it really helps to come up with something really short and hammer it home by repeating that over and over again. And I have 3 examples for you. In Berlin, after we did the Framework Convention and we were negotiating the next mandate for the agreement that became the Kyoto Protocol, the developing countries banded together and basically their mantra was no new commitments for developing countries, and essentially just said that over and over and over again until the point was made super clear. And that language actually ended up in the Berlin Mandate and was basically encapsulated in the Kyoto Protocol. After Kyoto, which the United States did not join, as you probably know, when we went to negotiate the next agreement, we wanted to make very sure that we would not bring home another Kyoto Protocol. So our pithy narrative became really 2 things. Legal symmetry was one of them. In other words, developed and developing countries needed to be under the same legal umbrella. And I'm sure people got very tired of us saying that all the time, but they understood the point. And the other thing we kept saying was no bifurcation, and people also got sick of that word. But the idea there was we should not perpetuate this kind of big gap between the developed and the developing countries. It should be more of a continuum without those categories. Now, skipping ahead to the Paris Agreement, the small island states and other vulnerable countries took on a motto, which was 1.5 to stay alive. And the idea there was they wanted to switch the temperature goal from what it had been, which was basically, we should limit the increase in global average temperature to below 2 degrees centigrade, that it should be reduced to 1.5. And that became the kind of rallying cry of Paris. It was all over posters and T-shirts and the like, and didn't become exactly the temperature goal of the Paris Agreement, but it's in there as part of the goal. So that's my first one, pithy narrative as negotiating position. The second is kind of a form of reverse engineering. And there I was thinking about the fact that what we have done sometimes is sat down with another country where we didn't necessarily agree with them and tried to figure out, well, what narrative do we both need to go home with? And this was absolutely the case when it came to the transparency provisions of the Paris Agreement. That was like about reporting and review. I won't name the country, but we sat down with an important country and didn't really agree. But what we decided to do is set aside the text of the agreement, which is a very unlawyer-like thing to do, is to set aside the words, but we forced ourselves. And we said, like, okay, when you go home, what do you need to be able to say about this article? And they wrote down 4 things. And we said, okay, when we go home, we're going to need to be able to say the following 4 things. And then we sort of compared notes and realized, like, there's nothing really incompatible about this list of 8 things. Now let's take back the text and see if we can incorporate our respective narratives working backwards into the text. So that's my second example of the use of narrative. My third is almost the polar opposite, which is sometimes when you compare narratives with another country or group of countries, you realize that your narratives are incompatible and they're not going to become compatible. And then you have to figure out, like, what do we do? And in some cases, many cases actually, you can come up with intentionally ambiguous language that preserves 2 different narratives. I'll give you an example of this because it's one of my favorite ones. I wish I had thought of it, but I didn't. We were negotiating the Framework Convention on Climate Change back in 1992, the very last issue, so extremely important, otherwise we would have had no Framework Convention. It involved the list of countries in Annex 1. Annex 1 was supposed to be the list of countries that were going to have higher responsibilities. Everybody agreed on which countries those were, right? There was already the list. But we didn't agree on how to characterize them. We thought, the developed countries, thought we could just say the parties listed in Annex 1. That's pretty straightforward. That's all you needed from a legal point of view. To some of the developing countries, that wasn't good enough. They wanted to say the developed country parties in Annex 1 and characterize them that way. Well, you had Russia, which had just, the Soviet Union had just fallen apart. And the Russians said, we're not a developed country. We're a country with an economy in transition. And over our dead bodies, are we going to be characterized as a developed country? Well, we were at a complete impasse because the other set of countries was insisting that this be the characterization. So some brilliant person looked at the list of the parties in Annex 1 and realized that one of the parties was the European Economic Community, which was precursor to the European Union, and realized that it was not a country. And they said, actually, it isn't even correct to say the developed country parties, because, you know, one of them is not a country. So why don't we say the developed country parties and other parties listed in Annex 1? And then some countries can go home and say, that's because the European Economic Community is in there. And others can go home and say, well, that's because Russia and other Eastern European countries are also developed countries. Okay, so to me, a perfect example of completely incompatible narratives, but you found a way through a beautiful ambiguity that allowed everybody to go home and preserve their narrative. Okay, so my fourth example is that narratives can be helpful for simplifying what negotiators have agreed to. And my example there is the Kyoto Protocol. And often, you know, you spend a couple years negotiating something. It's very difficult to summarize it in a few words. But a good example of a simplified narrative about an agreement was what the narrative that came out of the Kyoto Protocol, which was basically EU targets, US architecture. Because the big fight had been that the EU was pushing for very stringent emission reduction targets, and the US and friends were pushing for flexibility, emissions trading, that kind of thing. And, you know, the balance in the end of the day was really much more towards the EU position on the targets, much more towards the US and friends position on the architecture. So that's kind of an example of the use of narrative to simplify things. But at the same time, shorthand narrative, I think, can be very uncomfortable for lawyers because, you know, you go through all of the nuances of what you've agreed to, you know, exceptions and opt-ins, opt-outs and all kind of stuff. And it's very hard for lawyers, I think, we're reluctant to summarize because you lose all of that beautiful nuance. I think it's also been an issue for us in the climate world that scientists are reluctant to do the same thing. So you'll have like the IPCC reports, they're almost impenetrable. I don't know if you've ever opened one and tried to look at it, but like every sentence is, you know, with medium confidence, with low confidence, with high confidence. You know, it's very hard to read that and figure out what in the world is this trying to say. But when you try to get the scientists to summarize, they don't readily like to do that because they're kind of like lawyers in the sense that there are a million details and they don't really want to just give you a sentence because it's actually not quite accurate. But it reduces the significance of an IPCC report if the public doesn't understand it. And I remember that there were people at an organization I was working at one point who were training the scientists to try to get them to say things in, you know, a simple sentence. And one thing that came out of the IPCC report on 1.5 degrees was that the difference between 2-degree limit and 1.5 was that at 2 degrees, you know, all the coral reefs would die. And that was a perfect example of, you know, taking a very complicated report and reducing it to a narrative that actually could be understood. And I think it went into the New York Times, you know, front page, but it wasn't easy for the scientists to come up with that. You can also use in the same kind of cluster of summarizing with narrative, you can also use it in negative ways. And I remember the example of the Kyoto Protocol coming back to the United States in 1997, and the ad that was anti-Kyoto had a very effective narrative because it had a map of the world and a pair of, this was on a TV ad, it had a pair of scissors, you know, cutting off most of the world, and the map kind of fell off, fell down. And it basically said, the Kyoto Protocol, it's not global and it won't work. And it was an incredibly effective ad. So these kinds of narratives can also be used, I suppose also in positive ways, but that's an example of using it in a way that was like very effective in killing support for the Kyoto Protocol in the United States. Okay, my fifth and last example is narrative is a recurring issue and challenge for any country that is hosting the annual Conference of the Parties on climate. You know, they're usually very complicated. There are many issues that are going to be discussed at a COP, but you have to make your COP that year accessible to the public and the press. I mean, because these countries are asked repeatedly, what is your COP about? And if you can't say what it's about because it's about 1,000 things, you kind of lose the oomph. You also have to make it inviting to politicians. You're trying to get leaders to come. You're trying to get ministers to come. You know, back in the day, if you called a COP an implementation COP, it was basically dead on arrival, because implementation was like the most boring word anyone could imagine, even though it was, of course, the most important thing, you know, one could do. But if you called it implementation COP, you know, people would just yawn and say, no, thanks. So that's, you know, another challenge. Another is that you have to balance it exactly right, because you have to inspire ambition. You can't say our COP is about, you know, making microscopic progress on reducing emissions. At the same time, if you say we're going to, you know, use our COP to get on track to 1.5 degrees, you're overselling what you're going to achieve, and you run the risk of failure. So you have to find that exact kind of right sweet spot where you are inspiring action, but you're also not overselling and, you know, running the risk of failure. And finally, the last point, the most challenging thing is to sort of create a narrative when there isn't a natural one. And I just raised that because that's the case with the COP that's coming up in Brazil in a couple of weeks. There's no major mandated outcome. So it's not one of these COPs where it's obvious that it's going to be about, you know, adopting the Paris Agreement or concluding the rules under Paris or doing the first global stocktake under the agreement. Really, none of that is on the agenda. So it's up to the host country to kind of create the narrative. And if you pick too many things, which I think is the case this year, it's almost like too much is nothing, because people cannot wrap their arms around too many topics. So I'll stop there. Thanks.
Thank you, Sue. And I think I learned a lot about sort of public communication broadly from what you were discussing, and sort of creating a theory of the mind for the person that you're trying to communicate to. I think there are a lot of principles in there that are so useful for thinking about sort of policy communication across a number of different issues. So thank you for sharing that. Our fourth and final speaker is Rebecca Hamilton. She is a professor of law at American University Washington College of Law, where she teaches international law, national security law, and criminal law. And she was a 2024 U.S. Fulbright Scholar at the Islands and Small States Institute, and a fall 2023 visiting professor at UCLA Law. She is also an executive editor of Just Security and part of our wonderful Brain Trust. She's an internationally recognized expert on atrocity prevention, and she does a lot of scholarship around the structural underpinnings of international crimes, a lot of work across technology and climate. She has a background as a foreign correspondent, including for the Washington Post and Reuters, and an extensive background in international criminal law, including at the International Criminal Court and the Appeals Chamber of the International Criminal Tribunal for the former Yugoslavia. She's widely published as both a reporter and a legal academic, and is the author of, among other things, the book Fighting for Darfur, Public Action and the Struggle to Stop Genocide. She holds a JD from Harvard and an MPP from Harvard Kennedy School, and we're thrilled to have you here today. So over to you, Beck.
Thank you so much, everyone. And seriously, thank you for the Friday afternoon aspect of this. It's really wonderful to have you in the room. So I actually think my remarks are going to segue pretty well. I was going to come at this putting on my hat as a former journalist. And I wanted to chat a bit about journalistic narratives, and then a second piece on what I would maybe call cultural narratives. So starting on the journalistic narratives piece, and thinking, how do you deliver information that is in an IPCC report? There is a basic structure, and this is a generalization. There are many variations on this, but at its simplest, we are talking about enticing a mainstream reader in with your piece of candy. And then while they are enjoying that piece of candy, you are slipping in the broccoli. And then hopefully at the end of it, you wrap it up with a meal that has been enjoyable for the reader, but has also delivered the pieces of complicated information that they otherwise wouldn't engage with. Okay, so that's the formula. And if we can think of applying this in a climate context, you are starting off looking for a really compelling character. And mostly I'm going to be talking about this in relation to a person who is affected by climate change, but a coral reef is a compelling character, or a polar bear is a compelling character. We can talk about all of the problems with putting those up. But imagine we've just got our character who is affected by climate change, and you want to draw the reader in with as many personal details, as much color, get them captivating and caring about that individual. Once you've established that, then you can zoom out to provide the policy picture and the details and the dry materials that the reader otherwise wouldn't be going for, but is willing to stick with you for because of the character that you've introduced into the story. And then hopefully you've kept the reader through all that so that you can wrap up by showing how this character that they care about is deeply affected by what is otherwise a dry and complex, legally or scientifically, issue. Now, that sounds sort of cynical when I lay it out like that, but it's a really important concept, because we cannot get people reading dry material. You lose 80% of your audience if you start out with some of the language that is out there trying to describe these things in either scientific or legal terms. The other thing to say about the character that you choose is that they need to be relatable, and they need to have a problem or a story that is dramatic. Now, relatable is obviously a relational concept, so let me just kind of stipulate for this point here. Let me talk about a sort of mainstream North American audience. You have a different audience, it would be a different character that counts as relatable. But for a mainstream US audience, your farmer in Iowa is fairly relatable. Your community gardener in Brooklyn is fairly relatable. Relatable enough that you could get readers to care about their problem being a change in their planting season as a result of climate change, right? If, however, your character is a Pacific Islander living in Tuvalu, it is pretty hard to get a North American reader to care about shifts to a planting season due to climate change. You need to amp up the drama of the problem because you have a character that is less relatable for your core audience. So that's the inverse relationship between the two. And that is part of the explanation for why we have Time magazine cover stories that are about sinking states, right? You need that high drama of the sinking state story to get your audience connected to a character that they don't have personal experience and familiarity with. Now, those kinds of stories are actually extremely effective vehicles for getting people to read material about climate change, but they have costs. And so I just wanted to talk through some of the costs of that approach. One of them is I have seen over the last 20 years shifting, but there's a whole distance still to go, which is that there has long been a perception that the character is more engaging, more sympathetic, the more victimized that they are painted, right? And so you have the stereotype of ultimately that character being painted into a sort of victimization corner to get the buy-in of the reader. I actually think there are now some examples that show us that you don't have to do that to your character in order to get engagement. And there's actually an extremely compelling story to be told with a character that is resilient and fighting and creative and finding all of these strategies around the problem. But it takes more reporting time and more time to learn all of that, right? If you're doing a fly in, fly out story, you tend to just get the superficial victim layer narrative. And that is deeply, deeply problematic on many, many levels. But I would just say I've just been back in Aotearoa at Adaptation Futures and Pacifica youth who have been so extraordinary in this space. This was the call of every panel, like stop painting us as being in deficit here. We have the skills and the knowledge and we are doing this, and it's true. So that has historically, though, been one of the problems with these stories. The other is that when you set the bar so high, it's the sinking state story, then that sets an anchor point for other information that people are consuming about climate change, and over time risks the sense of the lesser drama stories don't feel like they're worth people's engagement. And then the final aspect of this is it feels like, and I'm shifting now from journalism into kind of mass mobilization experiences from human rights advocacy, but that apply in the climate space, is whenever you have a problem that is so big compared to most people's daily lives, there's a real risk that you, instead of getting engagement, end up with apathy. Because people feel paralyzed, they feel overwhelmed, they feel like, okay, you've got me caring about this problem, but there is nothing I can do. There is nothing I can do about a sinking state in the Pacific. And, you know, part of the challenge always in this calibration process of getting a public engaged is how to match problem and solution. And you're often starting out with a huge amount of daylight between the two. Interestingly, climate change is you know, on the problems that I have historically worked on, thinking about atrocity prevention, genocide in places that are often far removed, although also deeply close. But that scale of the problem, it feels impenetrable in a way that I think climate change offers a story that can be much, much closer in terms of what people can concretely do. Shifting though to what I'm calling cultural narrative, I was just thinking coming back from Aotearoa, and my stepdad is Maori, and so within that community or whānau, the stories that one grows up with are just radically different from the stories on which international environmental law has been based. And stories about how the world works, stories that come from ancestors that are absolutely relational and understand the interdependency between humans and the natural world, that see nature not as property, not as an object, but as living entities with knowledge that they can share with us. And, you know, this is not unique to Maori stories. It is in indigenous cultures across the world with very specific localized stories, but what is, I think, cross-cutting is that none of them are adopting the colonial binary between humans and nature. And yet that is what we have absorbed into international law. And so, one of my concerns as we move forward and try to get international law to really step up further in this moment of perceived climate crisis, the climate emergency that we're in, is a rush to do that without taking time to reassess the assumptions that international law is bringing to the table. And that if we rush into this and carry international law with all of those assumptions embedded in it as it currently stands, then we might be locking ourselves into something that ultimately is not going to be helpful. And that for me is a story of storytelling from birth about what is the reality of the world that we live in. So a few thoughts, and I look forward to the rest of the conversation.
Thank you so much, Beck. I think from here, we might put a few discussion questions to the panelists and kind of drawing across some of the themes. Maybe start with a pair of questions about the relationship between, back to your last point about sort of international law and its centrality, the relationship between the slower and more deliberative nature of a lot of these international processes, and also a lot of the story building and story development processes, and the sense of urgency that many rightfully feel around climate change. I'll ask two flavors of the question and then kind of put it over to the panelists, one pitched more toward advocacy and one more toward diplomacy, and panelists can pick to answer as they choose. Camila and Naima, maybe I'll start with a question that's sort of directed to you two and your work in advocacy. So for advocates who are engaged in litigation or other change-making efforts, there have been a number of important victories in recent years at world courts, regional courts, tribunals. But as you previewed, Camila, many of the implementing steps that follow take a lot of time, and there are many moving pieces. So I'd be curious to know a little bit more about how, and this is to both of you for in any order you want to answer, sort of how you see in operationalizing those court victories, both before, sort of as you're deciding what cases to bring, and then also after you've brought the cases and after you have a result, thinking about what next steps you want to implement. And I know this is also a huge part of your work, and you've written a whole article on it, but to the extent that you can, do you want to start, Naima, just for logistical reasons, and then we can throw it over to Camila?
Sure. Thank you
Great.
for that question. So it's been about 3 years now since the first request for an advisory opinion on climate change was submitted to the International Tribunal for the Law of the Sea by the Commission of Small Island States, or COSIS. And I remember so clearly being in Hamburg in May 2024 when the opinion was finally released. And the big question everyone was asking was, now what? We had just achieved this huge milestone, language that reinforced what frontline communities have been saying for decades. The tribunal there confirmed that greenhouse gas emissions are a form of marine pollution and that states have clear obligations under international law to prevent, reduce, and control them. But after the celebration came that harder question: how do we actually use this? How do small island states and frontline communities turn this legal victory into something that changes lives on the ground? And it was actually something that gave me quite a lot of anxiety, because here we were representing Tuvalu and Antigua and Barbuda and other member states, and we were aware of that responsibility to make it accessible, make this advisory opinion accessible to civil society, to governments. So I remember thinking at the time, now the real work begins, because for the communities we represent, legal language, as many of you have already mentioned, only matters if it leads to something tangible. Cleaner coastlines, for example, stronger ocean protections, fair climate policies, and ultimately the ability to remain in their homelands and to live with dignity and access to a clean and healthy environment. So when we think about translating these judgments into actionable policy, there are several key steps that come to mind. First, as I think Beck was mentioning before, we have to keep socializing these rulings and make them relatable, not just within governments, but across civil society and international policy spaces. COSIS, for example, has been focused for the last couple of years on using the advisory opinion from ITLOS, but now the string of advisory opinions from the Inter-American Court of Human Rights and the most recent advisory opinion from the International Court of Justice in creative ways to highlight how major industrial polluters from aviation to shipping are harming both our atmosphere and our oceans. And so we, through COSIS work, through my work with Ocean Vision Legal, we repeatedly use the language in these opinions as the framework for legal arguments and communications to governing bodies such as the UN Human Rights Council. And although these advisory opinions are not binding, when they are put in conversation with other technically non-binding resolutions like the human right to a clean and healthy environment, this has a domino effect, and it adds weight and value to the opinions. At the community level, we have to work to connect these global decisions to the realities of frontline communities. So this means helping people, everyday people, as well as governments, to understand what the advisory opinion actually says, that emissions are now recognized as a form of pollution, and there are obligations for states, and what that means for their rights and for state responsibilities. So I think, the onus is also on governments, especially those who helped initiate these proceedings, to lead. And one example that comes to mind is the recent ICJ opinion that affirmed that a clean and healthy and stable environment is a human right. And it highlighted that fossil fuel subsidies and new exploration licenses may amount to internationally wrongful acts. So what does this mean for a country like Vanuatu or Tuvalu that has been saying this for years, but is also trying to implement national measures and policies to reflect that language? So governments now have an opportunity to act concretely on these obligations. And one important pathway I would mention is through the United Nations climate process that high emitting countries can respond to these advisory opinions by submitting more ambitious NDCs or nationally determined contributions. They're plans for reducing emissions at the upcoming COP in November. So I think there's another example through constitutional reform, where certain protections are incorporated that reflect key aspects of one or more of the opinions, such as the obligation to conduct environmental impact assessments for activities that might cause substantial pollution to the environment or significant and harmful changes from greenhouse gas emissions, or to assist developing states in their efforts to address pollution from greenhouse gases, or to cooperate or pursue domestic mitigation measures. So I think our role and that of civil society more broadly is to push for governments to embed these obligations into domestic policy, while also empowering communities to use the advisory opinion as leverage and to demand accountability and transparency. So yeah, we have to ensure that translating these rulings into policy isn't just a legal exercise, but fosters and facilitates agency, so that these court victories are not just symbolic, but rather infrastructures of possibility. Yeah, I guess just to sum up, I think the advisory opinions are the beginning of a new phase of advocacy. We now have to ensure that the frontline community see the benefit and not just the promise. And on the topic of weighing urgency with needs for long-term consensus building processes, and navigating that tension is a constant negotiation, because on the one hand, the advisory opinions and international law provide a clear framework. States have the duties to protect people and the environment regardless of borders. On the other hand, diplomacy is complex. And so governments, of course, face domestic pressures, economic priorities, and various political constraints. What I've learned in my work is that the key is making the stakes real, and socializing these advisory opinions alongside internationally recognized human rights can help policymakers see that these are not just abstract obligations, but they are responsibilities with real human consequences. And once that becomes clear, it strengthens the case for prioritizing collective long-term action, even when it may appear to conflict with the short-term national interests. So to navigate that tension, I think you have to find ways of bridging these two worlds rather than doing away with or neglecting one or the other. These two worlds being the long-term collective imperative of climate justice and the immediate realities of domestic politics. So these advisory opinions can provide the legal foundation, while community engagement and advocacy create the political and moral leverage to act. I don't think it's linear or simple, but I do think it's where meaningful progress happens, when legal clarity, human stories, and political realities intersect. And many Pacific Island states have emphasized this, that climate change is a universal problem. From London to Lagos, communities are already experiencing its effects. So the urgency may look different depending on location, but the underlying reality is still the same. So this is still an immediate and shared responsibility for all. So once that understanding is internalized, it becomes easier to see why national interest must sometimes be weighed against broader legal obligations. I'll stop there.
Yeah.
So this is the question of the day, right? Is what do we do with now all of this crystallized legal obligations across domestic tribunals, but also international opinions? And I guess I want to pause for a second and say that was a battle, that was a narrative battle, right? Like these opinions, these decisions. I mean, the Paris Agreement, they didn't just come out of nowhere. I was just at an event last night where we were honoring Professor John Knox and Dr. David Boyd, who started the special rapporteurs and basically helped crystallize, along many others, the right to a healthy environment. And, to a lot of my students, when I talk to them about the right to a healthy environment is part of the human rights corpus, and right, they're like, of course, right? And no, actually not, of course. There's lots of historical reasons why that wasn't obvious maybe 10 years ago. And so I think what we've been hearing today is how so many people, lawyers, academics, advocates, journalists, right, have been telling stories, have been slowly pushing for the creation of narratives and then legal foundation, then hopefully then lead to action, right, and change, like real change. So I just want to name that because I do think the narratives have changed. The narratives that the climate justice movement used and is using have changed, and some of them have been more effective than others. And if you talked about climate change 10 years ago, polar bears, right? And there was a very intentional movement to think critically about science communication and to humanize stories. And now maybe we've gone too far, to Beck's point, right, about how are we telling the stories. So from my experience now as an academic, but as someone whose heart lies in climate advocacy, right, the question of what's next is a really kind of unsexy question, right? It's the question of implementation. And I think we still need people to be doing the movement part of this. But once the legal foundations are there, and I'm not saying every legal foundation is there, but we have so many more than before, it's a question of nitty-gritty, technical implementation. And that's going to look differently in different places. And there's a role for all of us, right, in that fight. Something that I struggle with in this question of narratives and litigation is that through my research, at least what I've found is that modest remedies, so things that are kind of more narrow, when plaintiffs go to court and ask for more narrow, simpler things, tend to win more. There's reasons for that. You can speculate, right? Maybe they seem less risky politically. Maybe you only have one defendant as opposed to 3, 4, 5 government agencies trying to implement something. And the paradox here is that climate change is urgent. I mean, 1.5, we're there, right? Like we're almost there. We're at 1 or something like that. So the paradox is like we want law to move boldly, right? And give us this sort of grand victories and progress. And law, I don't know if it's made for them. And I say that as a lawyer, as someone with a deep respect for the rule of law. But courts have historically not given us justice until maybe the social movements have created the narratives and the legal foundation. I mean, Brown versus Board, right? It wasn't until there was enough consensus in this country that then the Supreme Court, with a lot of advocacy and legal and strategic lawyering, right, ruled in that case. And I think that there's a lesson here from civil rights, from education, from housing, from other fields that are not climate that we can take into this fight. And my worry is that, is this a problem about narratives or is it about political will and willingness, right? And I think both are important and we have to think about both. But we know what the solutions are. Like experts have been publishing books and more articles and like, right, mitigation especially, and also adaptations. So at this point, it's not that I don't think narratives matter, but I don't think it's a question of just narratives. Yeah, so I'll leave it at that. Thank you.
Yeah, I think that is a very helpful perspective and sort of the zooming out and also thinking that we are in the midst of a narrative now that has been created and recognizing that, I think is a really valuable point. And also, Naima, I don't know how good the video is, but I just want to know there's like a lot of nodding and positive response to your to your comments as well in the room. Sue, I do have a sort of variation of that that's kind of about the diplomatic side. Shall I ask that? And then we can go to a broad question for everybody. Great. So I think it's a very similar question, which is this dynamic between sort of urgency, but also the time that it takes to develop consensus and to build relationships between stakeholders in the diplomatic setting. And that's both consensus across, from one country to another, but also within the domestic political setting where you might have various stakeholders with competing views. So how do you sort of see that tension playing out in the diplomatic space?
Well, it's no secret that the diplomatic process is pretty slow. We have a consensus-based process because we've never been able to agree on a rule of procedure other than consensus. So that's the default. And that means, with 197 countries or something, with wildly different interests, some of which view climate change as existential and some of which view the responses to climate change as existential, like the oil-producing countries, trying to get all of them to agree on something is extremely difficult, requires all the tools in the toolbox that we talked about before. So it's really it's not surprising that it's going to be slower than anyone would want, which is, I think, why there's been such a move to supplement the decisions that come out of, let's say, the Paris Agreement or the precursor to the Paris Agreement. So it used to be that you would go to a COP and really the only thing that people focused on and the only kind of outcome or product was a decision or an agreement, of the formal conference of the parties. Now, if you go to a COP, I call it the greater metropolitan COP, right? Because there's this outer, or now if you watch Severance, it's like the outie as opposed to the innie, there's this outer layer of all kinds of action that can go much faster and further than the things that you can do with a consensus decision-making. So for example, a couple of years ago when we were still in the Biden administration, we were trying to think of some kind of initiative that we would bring to the table when we had this major economies process. And we thought, we could either focus on a particular sector or we could focus on a particular greenhouse gas. So we went with this idea of a global methane pledge. And I think we wrote the pledge in like 7 minutes, right? Because it was 1 page long, wasn't a treaty or anything like that. We then called around to a bunch of countries. In about 3 months, we went from 0 to something like 120 countries, got philanthropies, the World Bank, a whole bunch of kind of funders to kick in millions of dollars. And, that initiative continues on even in the absence of a climate forward United States. So that's just one example. We now have all kinds of supplementary action surrounding the slow process, right? So when you look at climate action, you really have to look at the combination of the decisions that are sometimes thought of as like least common denominator because everybody has to agree on them, but you couple them with all these other things that are able to go much faster because either they're non-legally binding, they don't need to be ratified, or because you've got a small, subgroup of countries or the people or stakeholders who are involved are very motivated to go more quickly. So I think that's one sort of coping strategy for the fact that the diplomatic process is not fast enough.
And these insights are so helpful. And I think kind of a theme across all 3 responses is how complex and how many moving pieces they are. So before you go in a courtroom that you're thinking about building social movements and then afterwards, the many pieces that you take away and sort of in terms of next steps that Naima was describing. So it's complex questions with very complex answers, and really appreciate you thoughtfully engaging on these. We are mindful of everybody's time on a Friday evening, so I'm going to pose one question. Maybe, Beck, I'll kick it over to you and then also open the same question up to the rest of the group. And it is reflecting on the theme of this weekend, which is crisis as catalyst in international law. And the work that's being discussed today seems to be taking place across, a couple of different crises, probably more than that, but the climate crisis and also this sort of crisis in the rule-based order and a crisis of confidence in international law. So how do you see these 2 themes intersecting? And does the moment of crisis provide any opportunities for action?
Thank you. So it's been articulated sort of across the course of the day, a crisis in international law in the sense of we have key members of the P5 either committing or actively supporting states who are committing violations that go to the very, very core of the post-World War II order, right, in terms of Article 2.4. At the very same time, we have this surge of other states organizing and mobilizing, and this sudden slew of cases at the ICJ that would have been unimaginable 10 years ago. And what that speaks to is, as has long been the case, international law shines as a vehicle for countering power. That is the promise that I think it holds. And I think we see the same in the climate space, in a moment where so often I'll have students saying, what is the point of international law, right? We get versions of this all the time. When Pacific Island students faced with the urgency of the climate crisis looked around at the failure of the powerful to be doing anything, one of their core avenues for action was to say, let's get an advisory opinion out of the ICJ. And everyone said, it's not possible. And they kept going and they did it. And now we have it. And so there's a story of hope for international law there, I think. Certainly, I think international law would be in a much more problematic position in terms of legitimacy if it was ignoring these very present crises that are unfolding around us. But the other thing I think we need to do, just to bring it back to narrative, is to also remember to celebrate when there is success. And this was sort of to the point of like, we didn't get to having ITLOS, what the Inter-American Court is doing, what the ICJ has just done with it. That, it's truly an extraordinary opinion that they came out with. But that didn't happen without a lot of work going into it, and to appreciate that and harness it going forward.
Great, thank you. Does anybody else want to respond to that question? We can do another round.
Or audience.
So,
Yeah, well, why don't we do reverse order, and then Naima, you can have the last word at the end. So Sue, do you want to go?
yeah, well, I mean, given the climate crisis, I do think we need to respond. But I guess I would view, when we talk about international law being the response, I would just view international law very broadly, right? So things don't necessarily have to be legally binding, right? So in a sense, it's not law, but I would say, the world needs to come together and take all kinds of actions to supplement the international law. But I still think of that as part of the international kind of legal architecture in a way. I have a slightly different perspective on all the ICJ advisory opinion that I'll just throw out there, which I wrote about recently. Not to take away at all from the victory and all the good things that it will be used for once you all figure out how you're going to do that. But I do think one unintended consequence of the ICJ opinion is that it does take away some of the tools in the diplomatic toolbox, right? The way we are able to reach agreement in our process is through all kinds of nuance, very careful drafting, non-legally binding here, legally binding there, these words, this careful thing here. That's how we get almost 200 countries with different interests to agree on things. The court has taken some of those very nuanced decisions and has said that they created some kind of new law. I don't think that's correct in two of the cases. One being, I don't think there was subsequent agreement of the parties to change the temperature goal of the Paris Agreement to 1.5. That doesn't mean that we shouldn't be striving for 1.5 as a policy matter. Of course we should, but I don't think it's correct that the parties did that. And I didn't find the opinion persuasive at all on that point, or on the issue of NDCs, that parties' NDCs have to align with 1.5. In fact, the decision language that the world agreed to is that parties are encouraged to do that. It's the opposite of some kind of legally binding outcome. So my fear, I guess, is that countries are going to be more reluctant to agree to decisions in our process because they're going to worry. It's already difficult enough to get things over the finish line. I think they're going to worry that in taking the kinds of decisions that we've been taking up to now, they're going to think, uh-oh, am I now agreeing to something that's going to be considered a new legally binding obligation? So I think, that's just, I'm not saying that the court should have taken that into account. It's just a bit of a culture clash between a judicial world and a diplomatic world that now we have to figure out, what happens next.
Great, thank you. Camila?
It's hard to even know where to go because I have so many thoughts on everything that's been said. This question about crisis, crisis can lead to transformation. That's what I would like to think. That's what I tell my students, my really demoralized environmental law students. And then I also try to, again, tell stories about how we actually are in many ways much better than 50 years ago for many people in the world, right? I think this question of progress is not linear. It's not. It never has been. But I think about in terms of international law, the other thing we haven't really had a chance to talk about is like nature's rights. And I have lots of thoughts on nature's rights, and I'm not saying that I'm a supporter or against it necessarily, but if there's a lesson about narrative, it's one in the nature's rights movement. And to be able to now have global consensus and Human Rights Council resolution and UN General Assembly resolution, not necessarily on rights of nature, but harmony with nature, and we can talk about nuance and what that means, but that there's this like sort of emerging mainstreaming in the UN system, in some of these opinions, in court cases, of something that seemed crazy radical, a few decades ago, maybe a few years ago. I don't know what to do with that. I don't know if that's always good. I think there's questions about what happens when the law becomes so abstract and maybe nebulous, and then those legal obligations maybe don't mean as much as they used to. Like, again, I'm not saying it's a very easy, straightforward story of success, but I do think there is something here about how movements have used international law, to Beck's point, to claim fights that maybe seemed unthinkable of, and that now have reached the highest tribunals. And I think there's a success story there. And going forward, again, in a world where international law seems to be at a crisis, if anything, international law has always been about envisioning what the world could be. I mean, think about World War II and where our current regime comes from. I hope we don't need to have another World War to have a moment of transformation, but it's always been about the promise that the international law can hold. And so, I don't know, it's terrifying, but we're here and we have to do it. What's the other option, right?
Yep, yeah, very much agree. Naima?
Yeah, I really appreciate this question because it speaks to the myriad opportunities latent in this collective struggle for justice, climate justice. And that's really what should be giving us hope during a time when hope is a depleted resource. And so I see these, I guess, these two crises, the climate crisis and the erosion of confidence in the rules-based international order, as deeply interconnected. Both reveal limits in our existing systems. Climate change exposes, the inadequacy of governance to protect communities and ecosystems, while the legitimacy crisis exposes the gap between legal norms and their actual implementation. But I think moments of crisis can be certainly catalytic because they illuminate structural weaknesses and they force us to confront uncomfortable truths. Whose voices are represented, whose rights are protected, and whose perspectives are missing in the creation and application of the law. So the turbulence we see today underscores a fundamental reality that humanity's challenges are collective, and our responses must be collective as well. And so international law provides the framework for that collective action, but it's only as effective as it is inclusive, responsive, and grounded in the lived realities of those most affected. So, in essence, I think crises like these compel humanity to recognize our shared existence as a species. And that recognition should drive new patterns of organization, legally, politically, and socially, that are commensurate with today's challenges. And they unlock the full potential of the human experience and reinforce the legitimacy and relevance of international law itself. And I'm mindful of time, but I do want to just highlight, because I just returned from Tuvalu, and that's where I'm from. And I was consulting with families and community members about migration without necessarily putting the label of climate-induced migration there, and seeing what came up without me imposing anything about that framing. And of course, there's been a lot of media attention around a visa pathway between Australia and Tuvalu called the Whalepili Union. And many media outlets portrayed it as a climate treaty, which it is not, and suggested that tens of thousands of people in Tuvalu had applied. The reality is quite different. The program received about 8,000 applications across maybe 2,000 family groups, but most of the applicants were Tuvaluans already living outside of the country. Only 22 families based in Tuvalu applied. And I just saw a headline today saying that through this treaty, Tuvalu plans to migrate its entire population to Australia, which is simply not true. So this is an example of how narratives can be distorted and really, really damaging when they focus more on the deficits and vulnerability of certain populations rather than the injustice of the polluters. And I spoke with young climate activists in Tuvalu who shared their deep frustration and sadness at being asked to frame their responses in ways that fit the dominant narrative, that Tuvalu is a sinking island, when we know it's actually not, or solely defined by climate impact. And so, the narratives generated from the crisis, I think, we can't afford to have them perpetuate misrepresentation or be lacking in the necessary context, or be narratives that are shaped by virality rather than accuracy, because then we risk distorting perception and reinforcing harmful framings of these characters that don't actually resonate at all with how Pacific Islanders see themselves. So for climate vulnerable populations the world over, I think this can really flatten nuance and obscure lived experience. So, you know, in response to your question, Megan, I think the phrase justice as process, justice as outcome really rings true for me. And that's something that's coming to mind. You know, I'm thinking, how can we ensure that although we want to respond to the urgency, although we want to make you know, meaty treaties and scientific reports be accessible to as many people as possible, how can we still approach this in a way that doesn't leave a legacy of misrepresentation, and can also, and as Beck said, celebrate the successes of international law, and celebrate the strengths that are coming out of this population that's deeply affected by what's happening.
Well, thank you all so much. I think, I mean, this prompts a million questions and things we could continue to discuss. I have been told that some people have to get to an offsite event at 6, so we should wrap up. But wanted to thank the panelists. I think, you know, in the room, the conversation can continue. And Naima, thank you so much for joining us. Really, really valuable to have you here. So yeah, with that, thank you, everybody.